The CDC announcing new relaxed COVID-19 mitigations this coming yesterday, where they said essentially that things are being relaxed a bit, including the recommendations that you no longer have to be 6 feet apart from each other. It's something that's been in place since, April of 2020. So the recommendations range from when to test, when to quarantine, and how unvaccinated people are to be treated versus vaccinated people. And there doesn't really seem to be a distinction anymore, according to the CDC's guidance. But they updated the guidance that they have from the U.S. Centers for Disease Control and Prevention, saying that we should move away from quarantines and social distancing and focus on treating severe disease caused by the virus. And there also seems to be indication of focusing more of the asymptomatic testing on different places of high risk, like long-term care facilities or homeless shelters or correctional facilities and various other types of workplaces. But among the other various recommendations relaxing things, again, no longer recommending staying 6 feet away from people. Also, it's no longer recommended that unvaccinated people quarantine after exposure. Unvaccinated people who've been in close contact with those who are infected, they're no longer advised to go through a 5-day quarantine period if they haven't tested positive or show symptoms, according to the updated guidance from the CDC. In a statement, they said the CDC's COVID-19 prevention recommendations no longer differentiate between persons vaccinated and breakthrough infections, though they are generally mild, and persons who had COVID-19 and not vaccinated have a degree of protection against severe illness from their previous infection. So you're seeing that there's a recognition of the natural immunities that are built from people who do get sick. So with these updated guidelines, these relaxed guidelines, it'd be interesting to see what the Illinois Department of Public Health and the Illinois State Board of Education have to say. If they're going to issue new guidance reflecting the CDC, Governor J.B. Pritzker has previously said that that is indeed what they will do. They will have the state's guidelines mirror what the CDC guidelines are. Well, these new CDC guidelines saying that high levels of immunity among the population from vaccines and previous infection, it's no longer necessary to treat unvaccinated people differently than vaccinated people. Is that going to impact teachers in the state of Illinois who are still required to either test regularly or prove they got vaccinated? Is that going to impact college students who there's no longer a mandate, or college staff for that matter? There's no longer a mandate from the governor, but some schools are still requiring that and treating unvaccinated people differently than vaccinated people. But with these relaxed guidelines, I think that's given Anthony Fauci a bit of a license to make some jokes. So here is Dr. Anthony Fauci talking a bit about COVID-19 at a recent event where he made some jokes about the origins of COVID-19. So again, here's Dr. Anthony Fauci with apparently a new license to make jokes about the virus.
We're at the epicenter of the initial outbreak. WA1, Washington 1. Is considered the ancestral model strain.
I developed the ancestral model strain. I created it.
That's right. You let it loose.
I was in my kitchen.
You let it loose. Yeah. Right. Okay. Gain of function. Here we come. You're making aranja, Italian meatballs, and that's a gain of function.
Yeah, it's a joke now. Apparently, the origins of COVID-19, and in particular, you got to think about the past 2.5 years or so of the policies that Anthony Fauci, it was, don't worry about masks. Okay, put masks on. There's no general threat to the public. Oh, wait, now there's a general threat and we need to lock things down. We need to keep kids from school and so on. And the issue of the guidance in schools, at least here in Illinois, still very much a court case. And there earlier this week was a case heard in Sangamon County where you had attorney Tom DeVore and another attorney there looking to continue this lawsuit to challenge universal mandates and broad COVID-19 mitigations, especially in schools where kids were, in a way, not able to go to school and not able to have that in-person education, that in-person instruction. And here's some of the voices from that lawsuit that was heard in Sangamon County Court. You'll hear Patrick Walsh. He's an attorney looking to intervene in the case and add more plaintiffs, and that was actually granted on Wednesday. But you also hear Darren Kincaid. He's from the Illinois Attorney General's office. Melanie Rankin, she represents several school districts, and then Attorney Thomas DeVore. This is all unfolding in Sangamon County Court on Wednesday, where the judge ultimately took the motion to dismiss was what was in front of them, took that under advisement. And just a little bit more background here. This all stems from that lawsuit that was filed in November of last year by Attorney DeVore on behalf of hundreds of parents having their kids either kept from school, being forced to wear masks, and so on. But also a separate lawsuit dealing with vaccine mandates in schools and teachers having to either prove their vaccination status or test regularly. And these, of course, are two separate cases. They were both heard on Wednesday. But here's some of the back and forth on this case that, listen, it was filed in November. In February, if you recall, Sangamon County Judge Raylene Grishow, she ordered a temporary restraining order against the governor's mandates. The Joint Committee on Administrative Rules suspended those mandates on appeal to the Illinois Supreme Court. The Illinois Supreme Court said it's no longer valid, and they vacated the temporary restraining order, kicking it back to the Circuit Court in Sangamon County, and that's where the case is now. So you had all of that happening earlier this year, and the governor lifting mask mandates after the CDC changed their policies, and here we are again with another change of CDC guidelines. What's that going to mean for schools? It might mean relaxing of guidelines, but what does that mean for the future if there's any other similar instance? Are we going to see broad universal mandates again? And that's something that the plaintiffs in this case say violates their due process rights. Again, here's some of those arguments in Sangamon County Court this week.
These proceedings were expansive because Governor Pritzker issued sweeping executive orders and mandates and unlawful quarantines that affected almost everyone in this state, rather than giving people due process individually, as the Department of Public Health Act requires. Sweeping violations of due process, unfortunately for this courtroom, creates sweeping litigation.
The question of the new guidance, operative word guidance, just recommendations and suggestions from the state that may or may not be implemented by the school districts going forward. I think it's clear if you read it, and it's attached to various documents that have been filed in this case. It's also available on the internet, and you can take judicial notice of it. I think it's clear if you read that guidance that it's not binding on anyone at all. If you, school district, don't want to follow it, you don't have to. If you, school district, conclude you can't follow it because you don't have authority to, you don't have to. It's, from the state's perspective, purely recommendations. We think this would be a good idea, but if you disagree with us, that's fine. You can do it your own way.
I want to stop there and just kind of, reflect a moment. That's, again, Darren Kincaid from the Attorney General's office saying it's just guidance. And listen, the IDPH and ISB, they did issue new guidance that strongly recommends following CDC protocol, but it's not mandated. That was different last year, where you had school districts saying we're not going to force masks on kids, and the Pritzker administration and the Illinois State Board of Education was going after school districts, threatening their recognition status, which could have meant a lack of state funding. So there very much were consequences, and I think that's one thing that plaintiffs in this case are trying to make sure is clear, that there's a line drawn and where they can exactly mandate things, or if they have to go to the legislature to pass laws to mandate these things. Real quick, good morning. You're on WMAY.
Well, back in 1918, the Spanish influenza, even back then they were smart enough to know that masks didn't do any good, and that killed 1 million people. When the country with less than 100 million people. I mean, you think that people nowadays would be smart enough to understand that?
Well, we're not debating the effectiveness of masks. I think the question is more about the universal broad mandates that are on people. You can wear a mask if you want, and even the CDC is still recommending that you wear a mask if you're testing positive or if you have symptoms. But it's something that I think, we're seeing changing guidelines and how those are going to be implemented across the state. Back to some of the arguments in the Sangamon County courts about the mandates and whether or not the states can have schools mandate things broadly without the proper due process. Here is Darren Kincaid from the Attorney General's office talking again about how it's just recommendations, and he even equates it to the recommendations that you don't eat raw meat.
And there's nothing unusual about that at all, Your Honor. It happens all the time. I went to a little diner near my house the other day, one of those old school hole-in-the-wall type of places. And on the menu, the big menu that I got with all the burgers you could order, down at the bottom in big red letters it says, IDPH recommends that you do not consume meat that has been not fully cooked at a certain temperature, right? I mean, that was all printed on the menu. I'm serious. I saw it and I thought that's funny because that's exactly what we're dealing with in this case. It's just a recommendation. There are people at that diner and all over the state ordering their burgers cooked however they want, and just because IDPH thinks that you should do it a different way, that doesn't mean that you've been injured anyway. You can still get exactly what you want. And that's the issue here, Your Honor. The new guidance from the state, no one would have standing to challenge the state with respect to that guidance, because no one can say that that guidance injures them in any way. No one actually is compelled to follow it. It's purely advisory. So again, whether the school districts implement it or not, that's up to them.
If this policy is unlawful, God help us, because I would hope that every school district has a policy saying that if your child has a communicable disease, they shouldn't come to school, and they're going to be excluded from school. The state of Missouri has a statute saying they're not allowed to come to school. I don't know if, I'm sorry, I can't say if Illinois has that same statute off the top of my head. But the school, again, going back to these new guidelines that were issued in June of this year, if that's what plaintiff's counsel is referring to, this is basically nonsense. The school will observe recommendations of the IDPH regarding communicable diseases. If that's what we're saying is unlawful, we're going to have a whole lot of lawsuits coming down the pipe.
Kids are going back to school in week, 2 weeks, etc. And school districts and the governor probably desperately want this case to go away. And then where does that leave? What's practically going to happen, Judge? And you should consider this with your mootness argument. What's practically going to happen? I think Mr. Corney kind of mentioned it, is that the case is gone, school districts start doing all kinds of stuff. And he's right. Are they going to adopt the CDC/IDPH ISB guidance in some fashion? They're going to do some hybrid of that, etc.
So, again, that case taken under advisement. This happened before yesterday, the CDC relaxing guidance that says we're not going to treat vaccinated people different than unvaccinated people because there's wide levels of immunity from prior infection, from vaccination, and also a lot of different types of therapies. So we'll see what happens with this case taken under advisement, at least the arguments to try to make this moot. But you've got the plaintiff's attorneys saying that they need clarity on what exactly the state has the authority to do when it comes to broad recommendations and mandates that they say takes away due process rights. All right, that's the latest in the COVID-19